versus City of Nevermore. May I have announcements, please? Council may introduce themselves and who they represent.
Nevermore Plus Services. Morning, my name is Kelly Martinez. Yeah.
Hello, Natalie Gomez, representing defendant, the City of Nevermore.
Tina Cisneros, representing defendant, City of Nevermore.
Thank you, council. Announcements for time.
Each plaintiff will be utilizing 10 minutes.
Your Honor, defendant one will be utilizing 10 minutes, and my co-counsel 8 minutes, and then 2 for rebuttal.
Very good. Thank you, council.
May I ask for your names again, please?
Yes, Kendall Michaelis, Michaelis.
Thank you.
My name is Kelly Martinez. Cynthia, Chimchilla.
I'll remember Martinez.
Natalie Gomez, last name Gamez.
And I am defendant 2, Tina Cisneros, Cisneros.
Thank you.
Very good, council. When ready, you may approach the bench.
Chief Justice, may it please the court. My name is Natalie Gomez, along with my co-counsel, Tina Cisneros, and we represent the defendant, City of Nevermore, also known as the City. At this time, Your Honor, the defendant respectfully requests 2 minutes for rebuttal.
Granted.
Thank you. I will be addressing the first issue, and I will demonstrate that the plaintiff has not met organizational standing per Article 3 of the United States Constitution because the plaintiff has not met Haven's 2-pronged test. My co-counsel will address the second issue, and she will demonstrate that the plaintiff has not satisfied the second prong of Haven's, a diversion of resources, because pre-litigation expenses do not constitute a significant diversion of resources. For the foregoing reasons, we ask that this court grant the city's motion to dismiss. We ask that this court grant the city's motion to dismiss regarding the first issue for the following 2 reasons. 1, the plaintiff has not satisfied Haven's 2-pronged test. 2, the plaintiff has not sufficiently established that it suffered Haven's Haven's first prong, a frustration of purpose. Your Honors, we are here today because our client, the City of Nevermore, has exercised its broad police power of enacting an ordinance to regulate the unauthorized transportation and improper disposal of used and hypodermic needles. This ordinance was passed to address the hazardous threat posed to the city, the health, safety, and welfare of the community. Now, the plaintiff has expressed its concerns and objection to our lawful ordinance. However, Your Honors, we are not here to argue the merits of the case today. Simply put, the plaintiff has not established standing, and respectfully, this court should not grant standing when there is none. Turning to the first reason this court should grant the city's motion to dismiss, the plaintiff must prove an injury in fact per Haven's 2-pronged test. Article 3 states that the federal court system can only hear issues arising out of cases and controversies. And in Ballantyne versus United States, the Third Circuit tells us that standing is a jurisdictional issue. And in Lujan versus Defenders of Wildlife, the Supreme Court sets 3 elements to prove standing. But today, Your Honors, the focus is on the first element, which is injury in fact. But what Lujan does not inform us is how an organization proves that it suffered an injury in fact, which brings us to the precedent-setting Supreme Court case of Haven's Realty versus Coleman. The Supreme Court is the law of the land, and the plain language in Haven's makes it clear that the Supreme Court intended a 2-prong approach with the word with. And I quote, "Such concrete and demonstrable injury to the organization's activities with The consequent drain on the organization's resources was significant enough to satisfy an injury in fact. Your Honors, should the court have intended or by, we believe the court would have used that language. However, the court intended a two-prong approach of frustration of purpose and a diversion of resources.
Ms. Gomez, you continuously use the term two-prong test. Isn't there a split in authority as to whether it's a two-prong test or whether a party can establish one or the other?
Your Honor,
Establish standing?
yes, Your Honor, there is a split. However, we ask that this court rely not only on our interpretation, but also the interpretation of the Fourth, the Eighth, the Ninth, and the DC Circuit Courts, all which unanimously agree that it is a two-pronged approach. The plaintiff opposing counsel will tell you that it's a one-prong approach, and you may ask, what does it matter, one prong or two prongs? But a two-prong approach will set a clear and reliable standard for this jurisdiction, one in which would avoid meritless lawsuits and prevent the application of subpar standards. A one-prong approach would allow any nonprofit with an objection to the city's ordinances to hail the city into court to allege that it suffered an injury in fact through a frustration of its mission and spend legal costs on and claim that it's a diversion of resources and cause and attempt to seek damages. However, Your Honors, this would be an exceptionally low standard that would open the floodgates of litigation. We ask that this court help protect Article 3. Turning to the second reason this court should grant the city's motion to dismiss, the plaintiff has not proven the first prong of Havens, which is frustration of purpose. In Prevention of Cruelty to Animals versus Fell, the DC court ruled a frustration of purpose occurs when an organization's ability to provide resources and carry out its mission is impaired. Your Honors, by its own admission in Complaint Exhibit A, Paragraph 2, the plaintiff states that its mission was its needle exchange program. That was over 26 years ago. In 1997, when it opened and was named Nevermore Needle Exchange. However, according to Exhibit A, Paragraph 3, the plaintiff has changed its name and now is Nevermore Health Services, which represents its expanding mission. And by expanding mission, I mean that it offers around 14 different services that is more representative of its many services that is to promote, in its mission to promote healthier lives. That is the plaintiff's new mission. And the plaintiff will suggest that it's its core mission. However, the needle exchange program is just one component, and it is just a subset of the organization. Per the Eighth Circuit in National Federation of Blind Missouri versus Cross, the court tells us that experiencing a difficulty is not a frustration of purpose. A mere inconvenience to an organization's activities is not a frustration of purpose.
Counsel, if I could interrupt, well, aren't they now being required to reallocate their resources towards defending in this litigation? Isn't that depleting their resources that they otherwise would be using for their main purpose?
Your Honor, as my co-counsel will shortly elaborate on, the expenses towards legal fees by itself is not enough to constitute a significant diversion of resources. So the plaintiff has not proven frustration of purpose, prong 1, and frustration of purpose, prong 2, because legal fees enough are not alone. Which brings me to my next point.
Let me interrupt. What case do you rely on to support that proposition?
Yes, Your Honor. For the diversion of resources, my co-counsel will shortly discuss on, it's the Sampson case, and it's the fact that alone that diversion of resources is not enough. And that's also viewed as in Span versus the Village of Colonial, suggesting that self-inflicted injury is not sufficient to constitute a diversion of resources.
So how would you respond if I might follow up with a question? Opposing counsel is likely to raise this as well, because there is a split of circuits about whether or not one or the other alone is sufficient to provide an organization like a nonprofit, in this case, standing to sue. Now, in the context of the fact that this is it's a motion to dismiss under Federal Rule Procedure 12B1, which in spirit, as you understand, is really just kind of a gatekeeper, right? We want to make sure, does this organization, entity, or individual has standing? So it's not so much to preclude a cause of action, the merits of the cause of action, whether or not there's sufficient evidence to support the claims of the plaintiff is there. So given that there is ambiguity under the Supreme Court case in Haven, how would you respond to the argument I suspect your opposing counsel will make that say, well, even though there's a split of which prong or the other, the spirit of it is, we're not going to kick anybody out of court. We just want to make sure we avoid whether a frivolous filing or anybody that lacks standing. So to the extent that one would interpret arguably an ambiguous holding in Haven, in what context do you find that it would not be in direct contradiction of the Supreme Court case to find, as the lower court determined, that in fact only one is available? But why stop there, especially within the spirit of the motion to dismiss rule?
Your Honor, I see that I'm almost out of time. May I have a moment to answer your question?
Please do, and there may be a couple others, so we might give you a little bit more.
Yes, Your Honor. In the spirit of the one-prong versus two-prong approach, it's our contention that a two-prong approach would prevent that frivolous lawsuit and opening the floodgates of litigation. Requiring a proof of frustration of purpose and frustration of mission would avoid that. And it is our contention that the courts that ruled in favor of one prong got it wrong. And it is a two-prong approach, specifically pointing to the language in Havens that uses the word with, and it does not use the word by or.
Ms. Gomez, so going back to frustration of purpose or frustration of mission, you mentioned that Nevermore has expanded its services, but didn't it in 2017 distribute more needles than it ever has in its history?
Your Honor, recently it has it distributed more needles, and it is our contention that rather than running counter to the plaintiff's mission, our client's ordinance actually runs parallel to it, as seen in Rodriguez versus City of San Jose. At the end of the day, we both have the same end goal, and that is for the health, safety, and community of this Nevermore residents.
I have one question, just as a follow-up to Justice Rios. So back to your issue, which is frustration of purpose. I want you to talk a little bit about the causal connection between the harm to this particular group, to NHS, and explain to me how it's not particularized. And I understand that the distribution of needles has substantially been reduced over the years, but they still distribute needles. So tell me about the harm specific to them and the connection and how that does in fact frustrate their purpose.
Your Honor, in National Federation of Blind versus Missouri, an American Society for Prevention of Cruelty to Animals versus Feld Entertainment, the court was clear that a logical inference was not sufficient to prove standing. Your Honor, the ordinance simply regulates the unauthorized transportation of needles. The ordinance permits up to 8 needles for an individual to transport. The ordinance allows an organization such as the plaintiff to apply for a permit to become an authorized medical waste facility. So there is ample opportunity for the organization to continue serving its needle exchange program as it has for the last 26 years. And again, it would just allow us to work together to promote a healthier society for the Nevermore residents. Your Honors, for the following reasons, we ask that this court grant the city's motion to dismiss because the plaintiff has not met the two-pronged approach, because the plaintiff has not met the first prong of Havens, a frustration of purpose. We ask that this court grant the city's motion to dismiss. I'll now yield the floor to my co-counsel. Thank you.
Thank you, counsel. Probably have to do that all the time, don't you, Tina?
Thank you. Sorry. Chief Justice, may it please the court. My name is Tina Cisneros, and I too represent defendant City of Nevermore, also known as the city. I will address the second issue for review, which is the diversion of resources. This is the second prong to the injury in fact requirement for organizational standing. And this court should grant the city's motion to dismiss for the following two reasons. First, pre-litigation expenses related to litigation are insufficient to establish the injury in fact requirement. Second, the plaintiff has not sufficiently established that the city's ordinance has caused it to divert significant resources. In turning to the first reason, this court should grant the city's motion to dismiss. Pre-litigation expenses related to litigation are insufficient to establish the injury in fact requirement. The Fifth Circuit states, it's fundamental that no plaintiff may claim as injury its expenses in preparing for litigation. The Fifth Circuit additionally states that while every qualifying injury in fact necessarily does occur prior to litigation, it makes a crucial distinction between pre-litigation expenses related to litigation versus pre-litigation expenses unrelated to litigation. Now, this distinction is supported by the 11th Circuit, showing that the cost of challenging illegal practices is not injury. The 9th Circuit, showing a willingness to accept significant diversion of resources if it occurred from non-litigation activities. The DC Circuit, holding that redirecting resources to litigation and legal costs is insufficient to support standing.
Mrs. Nettles,
Yes, ma'am.
what about the $57,000 in expenses that Nevermore has incurred to determine the extent of damages or to formulate options to mitigate damages? Those are not pre-litigation expenses. Would you agree?
Your Honor, I would disagree. Within the complaint, paragraph 18, it also states that it's for legal fees and costs related to this instant action. And so that is where we're determining that they're applying these funds for legal counseling, which as law supports that it is not sufficient to establish injury in fact requirement. The plaintiff confirms this, as I just mentioned, that its expenses, and I quote, are for legal fees and costs related to this instant action. If an organization's only means of establishing diversion of resources, it's through its incurred expenses related to litigation, this court should find it insufficient. Turning to the second reason, this court should grant the city's motion to dismiss. The plaintiff has not sufficiently established that the city's ordinance has caused it to divert significant resources. As mentioned by my co-counsel, in 2015, the plaintiff expanded from exclusively providing clean needles to support those suffering from drug addiction to now providing a plethora of services to available Nevermore residents who are facing socioeconomic barriers. Now, since the plaintiff has also expressed that its infrastructure has grown significantly. And now with that, I'd like to direct the court to the record Exhibit B, page 3, which states, and I quote, "Despite our growth, meeting our extensive client-based needs remains a challenge." The plaintiff alleges that by the passage of this ordinance, our client has caused it harmful effects resulting in having to allegedly divert significant resources. And yet this allegation runs counter to its own admission found in the complaint. Further, the Second Circuit tells us that an organization suffers injury when it diverts resources away from its other current activities. We acknowledge that the plaintiff has incurred expenses of $57,039 to date. However, the plaintiff makes no mention of any of its other 13 existing activities or programs where funds were diverted from in response to our client's ordinance.
Mrs. Nettles?
Yes, Your Honor.
So, would you agree with me that a nonprofit organization's money is finite, right?
I
There's a
agree.
budget. And so with this law, Nevermore has to spend some money to come in compliance with the law. Is that a fair statement, do you think?
That's a fair statement that there would be funds that would have to be spent.
So that money has to come from somewhere. And probably from some of its other programs. So would you address that for us?
Yes, Your Honor. So if the funds would come from other resources and those resources suffered because of having to divert to comply, then we acknowledge that that would be diversion of resources. The issue is that the plaintiff is not establishing that. And we feel that if there are 13 other programs, it would be acceptable to share or demonstrate at least one of the programs that maybe they anticipate that they're going to divert from, or that they have already diverted from in order to try to comply.
Counsel,
Yes, Your Honor.
if I may, you seem to have a good grasp of the record, given the facts in this case, and pointing to the two cases that address the split among circuits in Nebi v. Douse and in slaughter this name, Moseki v. Miller. Each case discussed the split among circuits. Given the facts, the pleadings, which case do you think most reflects the disposition that supports your position before us?
Yes, Your Honor. So there is a split, and so we acknowledge that. Whether the circuit courts wants to establish one prong or two prong, or whether they go with a one prong or two prong, at the end of the day, one of them has to be met. And I'm here today to say that the diversion of resources has not been met. And the case that I would rely on is Fair Housing of Marin versus Combs. In this situation, a nonprofit that promotes equal housing through various activities, it did sue an apartment complex alleging discriminatory practices. But in this situation, there was losses to staff. There was more funds applied to bring on more volunteers. They had to bring awareness. There was an inability to continue its efforts, And this went, and specifically in the case, it also stated, and this was from the Ninth Circuit, that it stated these resources were above and beyond litigation. And for that reason, the court said that they met the sufficiently met the standard for diversion of resources. Your Honors, our client enacted the ordinance to establish guidelines for the safe distribution of needles with the intent of protecting the overall health of Nevermore citizens. And the plaintiff's allegation that our client caused it to divert significant resources is unfounded. Because pre-litigation expenses that relate to litigation are insufficient to establish injury in fact requirement, and because the plaintiff has not sufficiently established that our client's ordinance has caused it to divert significant resources, defendant City of Nevermore prays this court will grant its motion to dismiss. Thank you.
Thank you, counsel. You have 2 minutes reserved for rebuttal, yes?
2 minutes, yes.
Chief Justice, may it please the court. My name is Kendall Michaelis, and along with my co-counsel, Ms. Kelly Martinez-Chinchilla, we represent the plaintiff, Nevermore Health Services. I will be addressing the first issue for review, and I will demonstrate that Nevermore Health Services has Article 3 standing. My co-counsel will address the second issue, and she will demonstrate that the expenses incurred by Nevermore Health Services constitute a diversion of resources. This court should deny the City of Nevermore's motion to dismiss in regard to the first issue for the following 3 reasons. Firstly, Nevermore Health Services is able to prove a frustration of mission far beyond an abstract injury. Secondly, NHS's organizational standing to pursue injury in fact due to unequal treatment imposed upon NHS by governmental action, which is directly traceable to the ordinance. Thirdly, NHS is also able to formulate a redressable claim for the approximate value of relief per the request of the complaint. All of these factors that I have just mentioned are the qualifications per the Supreme Court for injury in fact in Lujan v. Defenders of Wildlife, and we are here today to show that the plaintiff can prove these. Turning to the first reason, the court should deny the motion to dismiss in the first requirement of injury in fact, NHS is able to prove an injury which is distinct and palpable, as well as specific to its mission as an organization.
NHS's core mission is to provide low or no cost support to Nevermore's racially and ethnically diverse residents facing drug addiction through the provision of clean needles. Although NHS has expanded beyond its original purpose solely as a needle exchange program, it is still the most widely used service, with the most needles being donated as recently as 2022, 86% of which were donated. Per Blunt v. Lower Merion School District, the Third Circuit held that a frustration of mission should perceptibly impair the mission of an organization, and NHS is able to prove that through the passage of the ordinance in which it would have to close its NEP. Per the Supreme Court in Havens, a specific injury is defined under a frustration of mission with a subsequent drain on resources. There is division regarding the requirement of one or two prongs. For example, in Village of Bellwood versus Duavetti, the Seventh Circuit ruled in favor of establishing one prong via the Havens decision. And furthermore, in Fair Employment Council of Greater Washington Incorporated versus BMC Marketing Corporation, the District Court for the District of Columbia established injury with only a frustration of mission. We strongly recommend the use of one prong so nonprofits are able to receive their day in court equally, and also as they are harmed with the loss of resources, they will be able to have those losses redressed.
Question.
Yes, Your Honor.
You heard counsel for the city share that there really is not as much ambiguity, that in fact it's clear because of the wording used in Haven. Where do you find, from your position, to differ on that point? Where is the ambiguity about whether or not Haven in fact is in fact dispositive that one prong or the other is insufficient, that two prongs are required?
Yes, Your Honor. The language in Havens with the word with ultimately implies a subsequent of the second prong. So we're looking at a frustration of mission with something else. Ultimately, we have other cases that show when one factor is suffered predominantly or far greater than the other, that it's ultimately okay to utilize one prong. So for example, when we're looking at the BMC marketing case, they ultimately had suffered a frustration of mission so strongly that it seemed the diversion of resources was not
If the court will
necessary.
agree that what with is like and, that if we're called to actually interpret an opinion, not a statute, but in the context of the whole opinion, within the spirit of its ruling, is there in fact ambiguity, and where does it lie? And why we shouldn't just hang our hat on the word with to draw the conclusion that Ms. Gomez would propose?
Yes, Your Honor. Ultimately, that ambiguity lies in different case law and the split in the circuit of interpretation. For this particular case, Nevermore Health Services is able to prove both prongs, but ultimately we're afraid of the consequences of doing as such for future nonprofit organizations such as ourselves. And ultimately, the consequences of that action would not permit other organizations that have suffered a similar injury to come forward with the fear that the court would not hear their claim. Furthermore, per the decision of Grassroots Collaborative versus the City of Chicago, the frustration of mission argument is ultimately considered more important in establishing an injury. In other words, an organization is injured when it faces a barrier to its key services due to the actions of the defendants, and a diversion of resources is not always necessary to prove that point. And so turning to the second reason the court should deny the motion to dismiss, NHS's injury is directly connected to the ordinance, holding NHS to a standard of a medical facility or medical waste facility when it is a nonprofit organization functioning solely on donations and other generosities is a barrier from governmental action. To hold a standard of certain medical facilities while not holding it for all is an unequal and disparate treatment, which establishes injury per the Supreme Court in Northeast Florida chapter of Associated General Contractors of America versus City of Jacksonville, Florida. Ultimately, with the ordinance in place, needle exchange itself is criminalized per the original ordinance on page 3 of Exhibit D, which would make the needle exchange, if not followed with those qualifications, a Class B misdemeanor.
Michaela, so is it Nevermore's position that receiving contributions of needles will be affected because this law prohibits the transportation of needles?
Yes, Your Honor. Nevermore Health Services is purposefully situated in downtown Nevermore to ultimately allow impoverished and racially diverse clientele and almost the largest portion of the population that suffers from intravenous diseases to easily access a needle exchange program and to go about this issue safely. Requiring a personally owned vehicle, most of which our clientele does not own or would not be able to access, is a barrier to promoting safe needle exchange, especially for the clientele which we target.
Will it frustrate the mission? I guess I'm trying to figure out, not only receiving contributions, needles in the form of contributions, but also distributing needles. So in those two steps that Nevermore provides this service, it has to receive the needles and then distribute. You're saying that this law is an obstacle.
Ultimately, it will impact the donation of those needles. So how Nevermore Health Services operates is it takes those donated needles and transports them to a medical waste facility, which is certified by the state. But ultimately, with this ordinance in place, we would not be able to move those needles and acquire new ones due to the requirement of the personally owned vehicle with a limitation of 8 needles.
Okay, so aren't the donated needles sterile? Does the record show whether the donated needles are sterile?
The record does not indicate, so I don't have that information, but if able to go forward, I can discover that information.
Well, the statute or the ordinance rather reads, it makes it unlawful for anyone not employed by a medical facility or authorized sanitation organization to transport or cause to be transported used or otherwise unsterile hypodermic needles.
Yes.
Okay, so you were just referring to the act of disposing of needles. Is that correct?
The needles are given by, so the needles that are donated are used back to Nevermore Health Services. Yes, that is correct.
Okay, but if we get into the weeds about the transportation of the needles themselves, isn't the ordinance only going to the transportation of unsterile needles?
Yes, Your Honor, which is the problem at hand, given the needles that the needle exchange operates on are used and donated to them. And so clientele bring in their used needles and receive new clean needles. And so in order to dispose, the Nevermore Health Services would be unable to dispose of those properly as they have done so due to this requirement. And so ultimately it would be on the clientele to donate their own needles, which is highly improbable given the clientele in which we serve.
So that's what you're saying is the root of the frustration of your mission.
Yes, Your Honor.
Thank you.
There's some discussion in Haven and some other courts, especially out of the DC court, about whether or not diversion of resources is really just a, consequence or a symptom of frustration of purpose, thereby basically implying that there's a suggestion that only one is necessary. Point to that language and tell me what you think about that.
Yes, so there is a case out of the DC circuit that notes that frustration of mission and diversion of resources are intertwined. And if you can prove one, it is easy to prove the other. And ultimately, we're not here to dispute the fact that of proving both, because Nevermore Health Services can prove both to qualify their injury. And ultimately, we know how important that is. We recognize our opposing counsel's argument that this could prove detrimental to the floodgates of litigation in the judicial economy. But ultimately, our fear rests in the fact that if not given the opportunity to have their day in court, nonprofit organizations ultimately have suffered and would not be able to have that claim redressed. Your Honor, I see I'm out of time.
I do have one more question.
Oh,
before
yes, Your Honor.
I leave the podium. So what is your position that the two prongs are so intertwined that we don't need to be concerned about whether it's one prong or two prong? Or earlier you stated that perhaps one element is weightier than the other, so you win either way. Do you win either way, or do you choose one or the other?
By that case, it's ultimately our opposing counsel's argument, which I'm conceding that I understand the ramifications of, and that we can see how one prong can lead to the other. And ultimately, that makes a clear-cut case of injury that can be heard by the court. And both prongs are easily proven. Although we are able to prove both prongs, it is more that we understand in certain circuits and in certain cases when one prong is weightier than the other, the courts have granted leeway when establishing that injury. And so we're not asking for that leeway today, but are choosing to bring this up in order to show not only the difference in circuits, but also the ramifications for a nonprofit organization as ourselves.
Thank you.
Anything further from the court? Thank you, counsel.
Thank you.
Chief Justice, and may it please the court. My name is Kelly Martinez Chinchilla, and I too represent the plaintiff, Nevermore Health Services. I will be addressing the second issue for review, and I will demonstrate that plaintiff Nevermore Health Services, also known as NHS, has suffered an injury in fact through a diversion of resources prong because it has diverted significant resources that go above and beyond litigation cost to counteract the defendant City of Nevermore's conduct. Your Honor, this court should deny the defendant City of Nevermore's motion to dismiss in regard to the second issue of litigation costs for the following two reasons. First, plaintiff has significantly diverted its resources to counter the defendant's conduct that go above and beyond litigation costs. And second, even when the plaintiff has diverted resources towards litigation costs, those costs are significant and traceable to a defendant's conduct to amount to a diversion of resources to show an injury in fact and establish standing. Turning to the first reason this court should deny the defendant's motion to dismiss, plaintiff has significantly diverted resources that go above and beyond litigation costs, which is evidenced by plaintiff deviating from routine activities related to its mission to counter the defendant's actions. The Ninth Circuit held in Fair Housing of Marion becomes that standing is proper when an organization's resources are diverted to counteract the defendant's conduct above and beyond litigation costs. Here, plaintiff has clearly diverted resources to counteract the defendant's conduct above and beyond litigation costs. For example, plaintiff engaged the services of legal counsel to assist in opposing the ordinance and urging the city not to adopt it as soon as they found out that the City of Nevermore planned to pass this ordinance. And this is an activity completely unrelated from plaintiff's routine activities, and as such, it constitutes a significant diversion of resources. As the Fifth Circuit held in Vote.org v. Callanan, when an organization has been forced to deviate from routine activities related to its mission to combat the defendant's actions, it has suffered an injury in fact because it has deviated significant resources such as time and efforts that could have been spent on furthering its mission. Similarly here, because plaintiff has significantly deviated from its routine activities to counter the defendant's actions, plaintiff here too has suffered an injury in fact through a diversion of resources
I have a
requirement.
question for you.
Yes, Your Honor.
How do you respond to the city's contention that really there's no evidence in the record, aside from 57 grand and change, that then is purely legal fees related to the investigation of the facts and of the ordinance and the effect of the ordinance on them, but it doesn't constitute actual injury evidence. And the citation she provided, how would you respond to that argument?
Yes, Your Honor. I would respond to opposing counsel's argument that although, the complaint does mention that it has spent about $57,000 in advocacy efforts and costs related to this litigation. I would respond that those advocacy efforts, for example, hiring counsel as soon as NHS found out that the city planned to pass this ordinance, constitutes a diversion of resources. Not only that, but as I mentioned, plaintiff is not in the business of litigating. Plaintiff has been a nonprofit organization for almost 27 years now and has never before gone before a court and tried to litigate an action. The case law that opposing counsel has cited to mostly deals with organizations that have suffered discrimination through the Fair Housing Act or 1983 actions, but those organizations are in the business, or their main purpose is litigating these types of actions, but NHS is not in the business of litigating. And for example, plaintiff hired in counsel to try to persuade the city of Nevermore not to pass the ordinance, those are resources expended. They not only spend money on it, but they also spend time and resources that could have gone to providing counseling and services to their clients, but they were forced to do it to try to oppose the ordinance. So I would say, Your Honor, that those should constitute a diversion of resources, because that was not plaintiff's endgame. Litigation was not the plaintiff endgame. So
Ms. Chinchilla,
Yes, Your Honor.
So this is a motion to dismiss.
yes, Your Honor.
We, the court, have to review the pleadings, right? The allegations made. This isn't a summary judgment. We don't really look at evidence, but and as I was reviewing, I see that Nevermore has not alleged that it has changed its budgeting or funding allocation as a result of this law. What allegations has Nevermore made with regard to diversion of resources?
Yes, Your Honor. The allegations that plaintiff has made as regard to diversion of resources are found in the complaint paragraph 18, and also in Exhibit A, the affidavit of Gomez Adamses, the director of Nevermore. In paragraph 8, he mentions that after becoming awarded of Nevermore City Council was considering an ordinance prohibiting the transportation of used needles and syringes within the cities, NHS engaged with services of legal counsel to assist in opposing the ordinance and urging the city not to adopt it. Informal advocacy efforts to oppose the ordinance have cost NHS approximately $57,039 to date. And Your Honor, as Lujan B. Defenders of Wildlife held, at the pleading stage, general factual allegations of injury resulting from the defendant's conduct may suffice. For a motion to dismiss, we presume that general allegations embrace those specific facts that are necessary to support the claim. So here, although plaintiff has not explicitly stated that they've tried to adjust budget or that they've tried to comply with the ordinance, general factual allegations should suffice here, and everything else will be discoverable as we move through this litigation. Additionally, Your Honor, the Third Circuit held in Blunt v. Lower that a court does not expect a plaintiff to climb Mount Everest to establish standing on a motion to dismiss. And so we ask that, as stated in the record, those allegations are accepted as true and that we are allowed to move forward, and everything else will be discoverable as we move through it. Additionally, Your Honor, the DC opposing counsel cited to Spam v. Colonial Village, but the DC Circuit in that same case also mentioned that the fact that the alleged harm affects the organization's non-economic interest, for example, its interest in encouraging open housing, does not deprive the organization of standing. And Spam went forward and further interpreted that into meaning that diversion of resources does not necessarily mean money, but it also means time and effort. And the fact that plaintiffs' mission was frustrated, they deviated from routine activities, and that the fact that it's not economic, that also constitutes a frustration of mission. Clearly, plaintiff here has presented more than a conjecture or a conclusory assertion. Plaintiff has mentioned, as I have said, that he has spent about $57,000 in advocacy efforts and litigation costs. And with this cost, it has also been time and efforts, and therefore, similarly to Fair Housing Council of San Fernando Valley v. Roommate.com, where the court held that standing was proper as to diversion of resources because the organization diverted resources to counteract the defendant's actions prior to the litigation, and that was enough to constitute an injury, in fact. Turning to the second reason, this court should deny the defendant's motion to dismiss. Even when plaintiff has diverted resources towards litigation costs, those costs can be enough to show a diversion of resources to establish injury in fact and standing. The Seventh Circuit in Village of Bellwood v. Rivedi held that the injury needed to be shown to establish standing is the deflection of the agency's resources from its mission toward legal efforts to counter the defendant's alleged conduct. Here, plaintiff has clearly diverted resources toward litigation costs to counter the defendant's conduct through the enacted ordinance. That is because it is clear on the face of the ordinance that it will hinder plaintiff's overall mission, and it's imperative for plaintiff to counter it so that it can continue to operate in the city of Nevermore. Further, the DC Circuit in Equal Rights Center v. Post Properties elaborated that the critical question when examining a plaintiff's proper diversion of resources is whether they undertook the expenditures in response to and to counteract the effects of the defendant's discrimination rather than in anticipation of litigation.
Counsel,
And,
I'm sorry,
yes,
could I interrupt
yes,
you
Your
just
Honor.
briefly? On your mission, hasn't the mission of the organization expanded now? Can you address how now your mission has expanded into providing other services? And how does that weigh into the argument that we need to consider?
Yes, Your Honor. I see that I'm almost out of time. May I answer the question? Thank you. That is correct. In 2015, plaintiff expanded its mission, but that is the key word. It expanded its mission. But its mission remains at the core of the mission to provide healthcare and to prevent the spread of ill-born diseases in the city of Nevermore. And so even though the mission has been expanded, at the core of it, it's the needle exchange program. Plaintiff it's been 9 years since it changed its name and expanded its mission and its services, but the city of Nevermore knew plaintiff since 1997 until 2017 as the needle exchange program. And that hasn't changed, which is evidenced by the complaint that it mentions that in up to 2022, around 86% of the donations were with needles, and its most profitable, not profitable per se, but it's more used service was the needle exchange program. So the city of Nevermore has known NHS as this service that provides needle exchange program.
Do you have any support or evidence that shows any frustration of purpose to the rest of your, to the rest of the programs that you now provide? And is that necessary for us to consider?
At the moment, we don't have any evidence, but that will be definitely discoverable as we move through this litigation. However, I don't think it should be considered at the moment, Your Honor, because the fact that that its main service has been frustrated, that will definitely cause a domino effect, and it will frustrate the rest of the services that Nevermore Health Services provides. And yes, Your Honor.
Thank you.
I have one question.
Yes, Your Honor.
I just want to clarify, I thought I heard you say something. Most of the cases that are cited by the plaintiffs involve fair housing and they involve equal protection. And it sounded like you were distinguishing the nonprofit and the pre-litigation expenses versus your fair housing, equal protection. And I thought I heard you say, well, they're in a position to spend money for litigation. That it's expected that they would versus our nonprofit, or it's not expected that we would pay expenses or pre-litigation expenses. So would you just clarify that for me?
Yes, Your Honor, that is what I meant. The case law that opposing counsel has cited to mostly deals with that. For example, they're like home organizations, and that is their job. They hire testers and they try to prove that discrimination has happened. And so they're in the business of, that is their core mission, to hire testers to try to find out if discrimination has happened and then move those actions before a court. But our organization, that is not their mission. Their mission is just to provide safe, clean needles and to try to prevent the spread of ill-born diseases. And as I mentioned, they've been going on and strong for almost 27 years now in July. And up till now, they have never had to litigate something. So I will say, Your Honor, that is the main difference here.
Okay.
And for the foregoing reasons, Your Honors, we pray that this court deny the defendant City of Nevermore's motion to dismiss. Thank you.
Thank you, counsel. Both parties, the case has now been submitted before the. Pardon me. Rebuttal, please. My apologies, Counsel Cisneros. Okay, tell me
All right.
what you think about their position.
Well, may it please the court, I have about 2 points to make, but happy to take any of your questions as well. Regarding the first plaintiff's argument, now, I would like to, the first issue is on the mission. So I'd like to read the mission. Our mission is to promote healthier lives and communities. And so we are here today to say that we are not frustrating the mission. There are 13 other activities, some of them consisting of under community education, health screening. The needle exchange program is but a subset of one of the addiction services. And so which leads to our argument that we are certainly not frustrating or causing a frustration to pursue the mission. Now, opposing counsel mentioned that the needle exchange program is the most viable used service. Now, Exhibit B, page 5, shows that 58% is for addiction services, but we do not know how much of that is the needle exchange program. So the needle exchange program falls under addiction services, but we just don't know. That could be 1%, 5%. We don't know how much of that is to.
At this juncture, Mrs. Nettles, are the plaintiffs required to show and establish the breakdown of the percentages? Isn't that an opportunity in terms of discovery post this step in the process?
That could be addressed at discovery, Your Honor. The reason I brought this up is just that they're using that strong language to say that it's it's the most viable, and thus determining that we're frustrating, which we certainly are not, and that's not our intent. I'd also like to address, and actually, Justice Chapa, you did bring up a great point as well, that the donations that are coming, one would assume that they're donating clean needles. And so certainly not impacting that ability to bring on clean needles. The ordinance is more for used unsterile needles. And I'd also like to shift, actually, I saw that I just ran out of time. I apologize. So for the foregoing reasons, we do request that the court grant the motion to dismiss.
I did have a question.
Oh, yes, I'm sorry.
My first question, responding to Council Martinez Chinchilla, forgive me. Position about, in response to some questioning by my colleagues, the distinction between a nonprofit organization like plaintiffs and say other organizations that fall under the statute that are more of an advocate than a community service. Advocate in the sense that they do, on behalf of a claimant, pursue a claim under, for example, the Fair Housing Act or other federal statutes. To the extent that that is a distinction, how would you respond to her position on that? It would be uncontested that the needle exchange program is not one to even have the resources, certainly not within its mission, that it would pursue any claim on behalf of any customer, as it were. So what's your position on that?
So our position is that we certainly acknowledge that the needle exchange program the Nevermore Health Services is made up of nurses, staff, volunteers, administrators, none of which can provide legal counsel to them. And so as opposing counsel mentioned, would have had to seek some assistance. But the main issue in regarding the law is that even if that were be the case and they're spending it towards litigation, it still is not enough to establish diversion of resources. And we'd also want to see where those funds were diverted from in order to cover those costs, which brings me back to our argument is that we just don't know, and they have not established that within the complaint.
Anything further?
Any other questions?
No further questions. Thank you,
Thank you so
counsel.
much.
Now I will say the case has been submitted and we will come back with a ruling shortly.
All right. Maybe seated.
Thank you so much. I don't know, he from Kansas, those family, I'm actually as well, so he came to explain. Yes, I do. I graduated in May. My mom. Yeah, and quiet, Yeah, so the guys all want to experience. Yes. Yes, yeah, because I ended up like. Yes. So I ended up like. Yeah, exactly. Scholarships.
Yes. 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 All right.
Morning again, please be seated. Well, another day at the courthouse, another year at the courthouse. The Fourth Court is delighted to host the annual Moot Court Finals for the students and advocates at St. Mary's School of Law. It is, of course, named, its namesake is let me recognize Mr. and Mrs. Schlueter, who are in the audience here at the courtroom. I'll also recognize Dean Patricia Roberts, who's very kind to appear, her a reflection of her continued support for competitions like this, among many. that provide the law students, in this case, the 1Ls, an opportunity to shine. Let me first also introduce the members of the court. And to my far right is Justice Lisa Rodriguez. To my immediate right is Justice Luz Elena Chapa. To my immediate left is Justice Irene Rios. And to my far left is Justice Lori Valenzuela. Two other members of the court, Justices Patricia Alvarez and Justice Beth Watkins, send their regrets, but they're here in spirit in support of this competition. I send greetings to our virtual audience because we have continued our tradition to be able to live stream and archive this competition for those who wish to view both live, as I'm sure there's students and faculty back on campus viewing, and of course, something that you can enjoy in posterity and share with your loved ones, both present and future. Let me first also applaud the efforts of our advocates today. Before I announce what we are charged to do is to decide the winners of best team and best advocate. I applaud counsel Natalie Gomez, Tina Cisneros, Kendall Michaelis, and Kelly Martinez Chinchilla. We are impressed. As you can tell, we excused ourselves and to deliberate, and it was a tough call. We are always amazed about the caliber of advocacy that is evident in these competitions. This year is no different. Each of you have shined brightly and reflect both the efforts that you have contributed to this competition from the inception. I understand that every 1L student participates. So the fact that, just love it that you're all women and Latinas as well. So you again have shined, and you are again the best reflection of the contributions that have been provided to you at the institution that is St. Mary's Law. So you will continue to impress both locally and statewide, if not nationally, because I anticipate that one or all of you will continue your moot court competition. So I look forward to you bringing home trophies as a second L and maybe as a third L student at St. Mary's. Dean Roberts is nodding her head up and down. So we expect it. And of course, St. Mary's under the dean's leadership also has in the past, because I follow y'all on Facebook. I don't follow a lot of people. St. Mary's Law and the Board of Advocates, I certainly do. And I'm always proud to see that a member of that legal community comes back with trophies. So a blousel to the university, and much applause and gratitude to Mr. and Mrs. Schlueter to continue to host this competition. I am the Lone Ranger up here on the bench. I'm not an alum of St. Mary's, but my colleagues are, some of them with dual degrees. And so I know that they share also a point of pride as proud alumnus of this law school. I will now announce the winners. The best team will be the plaintiffs, Kendall Michaelis and Kelly Martinez Chinchilla, and the best advocate, also Kelly Martinez Chinchilla. I will invite my colleagues if they want to make any brief comments.
I'll be brief. Congratulations to the four of you. I can tell you that you've blown us away. You give us great hope for the future of our profession. The level of the high level of grasp, the content, the material, the delivery, your poise. Ms. Gomez, you have such incredible presence. You maintained eye contact throughout. Your delivery was incredible. I see you as an advocate in the courtroom and outside the courtroom. Ms. Cisneros, your delivery in terms of responding to the questions, you handled them with grace, and you also pushed back a little at times, but you did so with grace and professionalism, and that was courageous. Ms. Michaelis, you were very fast at times, and so it was, but I think that goes to the fact that you knew that you had a time limit and you wanted to deliver as much information as possible. And you two had incredible grasp of the information, the content. Your responses were incredible. Ms. Martinez Chinchilla, we couldn't break you or get you to, kind of pause. You had the ability to think outside the box in terms of what was in front of you. And that, I think to all of us was very impressive in the sense of you spoke like a practitioner today. And so I see you as an appellate advocate in the future, and I congratulate the four of you. You're incredible. Today's outcome is just more to come. And like Dean Roberts, she was shaking her head because she believes in you. And the 2 L's and the 3 L's that are there right now, I know that you're going to follow in their footsteps and bring trophies home. You're making national coverage. And so that's really impressive as a dual graduate from St. Mary's University. So congratulations today. Very impressive. Thank you for being here also.
And I guess I'll follow by saying that we deliberated for a long time for good reason. You gave us a lot to think about, and it was a difficult decision. If we could put the four of you into one person, you'd be like the most amazing lawyer, appellate lawyer. But I just want to say that your delivery, your grasp of the cases was excellent. And so one of the things that I look at is, when you're asked a question, can you kind of get off your outline, answer it, and then come back? And, that's just something that I thought all of you did very well. And, we had to choose a best advocate, and it was close. And I just want to say, keep working hard, keep doing what you're doing. You're obviously very good at this, or you wouldn't be in this round. So I encourage you to let this be the beginning of your competition, so that you can go out and represent St. Mary's and make all of us very proud. I think we're very proud seeing the four of you here and the caliber of advocates that you all are. Thank you so much.
But with nothing further, I would be remiss if I did not acknowledge the support that the law school has provided you. And that begins with, of course, your board of advocates. I'll recognize Chair Amy Felicis, who's here. Amy, there you go. Thank you, Amy. Vice Chair Gabby Salinas, and the 1L Moot Court Co-Director Carson Winicky. Thank you and welcome again to the court. And I'd like to acknowledge that Professors Eskridge, Professor Wilson, and of course, Professor Aleman are also here, all in support. I also see several family members of our advocates. Welcome. I'm sure you sit there also with great pride to see not just the performance, but there's just one more notch on all of your belts in your journey through law school. And we look forward to you joining the bar, local or state for sure. So welcome to everyone. I know that we'll want to take some photographs with you before you have to depart. So with that, court is adjourned.
A round of applause for you.
And a round of applause.